Some things that the business is doing may need to get court approval. Let me give you a very simple example. Let's just say, for argument's sake, that one of the assets of the business is rental property. And so this business is renting out this property to some entity, and the business also has a mortgage on the property. Well, you can bet dollars to donuts that the mortgage has a section called an assignment of rents. Now, what does that mean? Well, when the business took out that mortgage and for the rental property, it agreed that the mortgage company, the bank, whatever that entity, that lender is, has a claim against the rent that's being paid by the renter. Now, if the business is making its mortgage payments just like clockwork, no problem, nobody cares. But suppose the business isn't making those mortgage payments. Well, then the bank has a claim against the rent that's coming in. That rent then is a type of asset called cash collateral. Now, when the business files for bankruptcy protection, business can't use that cash collateral because technically somebody else has a claim against it, unless either that bank agrees to allow the debtor to use that money or the debtor gets the judge's permission. And so we typically will file something called a cash collateral motion. It's one of a bunch of motions called first day motions. And in spite of the name, they don't necessarily have to be filed and heard on the first day of the case. It's just a term of art there. But in any event, the business can't operate just as usual without getting court's permission to use that cash collateral. Another type of motion that comes up, well, the business may have employees. And if those employees aren't being paid, well, they're going to hit the road and the business is going to collapse. So the business may need to file a motion for authority to pay the employees and set up a separate bank account. There's a series of bank accounts the debtor is going to have to set up and use that money to pay the employees. And by the way, to get back to the bank accounts, when the business files for bankruptcy protection, it's required to close all of its bank accounts and open up new accounts called debtor in possession accounts. The shorthand is DIP accounts. You might have a DIP account to pay taxes, a DIP account to pay employees, a DIP account for the general fund, maybe a DIP account for certain special kinds of uses. And so all of that has to be done with very close oversight by the bankruptcy judge assigned to the case and by the Office of the United States Trustee. So long and short of it is, with the court's permission, you'll be able to run your business as usual, but you're going to have to get the court's permission to do that. And that's done typically using those first day motions. And there's a whole collection of them that we file shortly after the case has been filed.